Let's start. So, my name is Ivan van den Brande. I'm a technology lawyer. I study both law and information science, and so that's why I'm assisting technology companies for the better of 12 years now. Today we are going to talk about cloud agreements. It's a quick scan. There's a lot to say about cloud agreements, so I try to keep it brief and to the point. Technically, we sometimes make the difference between software as a service, platform as a service, infrastructure as a service. Legally, we don't differentiate between these. We just call them cloud contracts. There are some small differences. For instance, with infrastructures as a service, there might be hardware aspects, but the rest of the contracts are the same, and we don't differentiate. So, cloud contracts, they often look really easy, really short, but don't make a mistake. There are general conditions, specific conditions, the service level agreement, the acceptable use policy, the privacy policy. They are all part of it, and they are binding. So you will see they are incorporated by a link or by a reference. It's up to you to go and look for them, and it's binding, at least under Belgian law, on the most European laws, and on the most international laws. You'd better presume that it's binding. So I'm gonna give some examples. If there's red text in my slides, it's examples, and I just took them from the Amazon Web Services customer agreement, the last version from 2011, and the Amazon Cloud Front Service Level Agreement, the one from 2010. I could have taken other examples, Google or something. They're all similar, actually. These standard cloud contracts you will find on the internet, they are really easy to get with a click and a credit card. You're going, and you can really easy scale up. So it's just with one click. Well, the one click, it will bind you. Actually, some people think, well, it's just one click, especially if you act as a company. If you're a customer, it's somewhere like an individual, a natural person. It might be different and a little more complicated. But if you act as a commercial party, then it's perfectly binding. Documents, we saw all the list of documents where they refer to just with a link. Well, it's up to you as a commercial party to go and look for them. So it's binding. They standard agreements. They are always unbalanced. They're always pro-provider, cloud provider, and it's valid. If you accept an unbalanced agreement, well, you accepted it. So it's binding, whatever is written there. So if you accept them with your one click, you shouldn't complain about the content if you didn't bother to read it. So they are easy to enter into. They are most often unfair, but binding. Don't forget it. People think that it's Amazon or it's Google. It will be safe, and they back it up. They have all these routines to make sure that everything goes safe. Well, if we look at it, and these are just two examples. When I was drafting these slides, sometimes it just go wrong. Also with these bigger firms. For instance, with KPN, in the beginning of March, when I drafted these slides, the city of Amsterdam was out of email. They just didn't have email access for like a week, and there was not a lot they could do because of their agreements. What else? They even lost emails, and if your contract doesn't help you, well, even with KPN, you don't have any recourse. The other one is Voelspriet. It's a Dutch search engine. It's based on Google. It's valid under the Google agreement to incorporate search engine in your site. So technically they don't do anything wrong, but suddenly they were cut off. Probably, or maybe Google doesn't really like that you create your own search engine on top of it. Well, suddenly they were gone. So if you build a business around these kinds of services, you completely depend upon, And sometimes it's a technical issue, sometimes it's a policy issue. For instance, for the Belgians among us, we have a famous comic characters, Suske and Wiske. It's for child, it's really innocent, and it's about, there is one particular comic and it's called De Zwarte Madame, the Black Woman, and it's about a witch. Well, but Apple, they made an application of it, an app, and Apple refused it because Zwarte Madame, a black woman, it might have been yeah, racist or something. They didn't accept it. So it's also these kind of things. Other ones, Humo, for instance, a famous magazine, they had a picture of a woman with bare breasts on the cover, so Facebook refused them. So it's all these kinds of policy, you have to take them into account. Sometimes you think Amazon, Google, and all these American companies, they are reliable, yes, but they have their own policies, so take that also into account when you accept their contracts. So, negotiation of cloud contracts, they are presented as is on the internet, but most of them you just can negotiate. I'm negotiating with clients on contracts, with cloud vendors, it's possible. I didn't do it myself, but a colleague of mine actually negotiated a 200,000 euro contract with Google, and Google is perfectly willing to accommodate them. So nobody likes to lose clients. So if you're a paying client and you have an issue with a contract, or if you want to build a sustainable business on a cloud service, just ask the provider to negotiate the contract. If it's a no, you know it, and you might look for another one who wants to negotiate. So for clients, negotiating the contracts is a reduction of risk. For suppliers, if there are some amongst in the room, I gave this speech for CIONet, and there were several suppliers. Yeah.
What kind of conditions do you usually negotiate?
Well,
for example, Google, that one.
It's all of them. Well, I took 12 examples. We are going to talk about 12 because you just can't. I just can't talk about all the agreements. So I just took 12 examples out of these agreements, that out of the Amazon agreements. I think, okay, this is kind of unbalanced, and you find them in several agreements. So that's things, 12 issues you might want to think about. So the first one, can the provider change the contract unilaterally? Right, normally we are used to receive the contract of I don't know, your boss, the employer. You're not, your employer cannot just change your contract. It's not accepted. The same if you rent a room or something, or a house, they can't change the contract. Well, here the standard cloud contracts, for instance the Amazon Web Services contract, they can change the contract at any time, and you agree to be bound. It's your, they don't even tell you if they change the contract. It's your responsibility to check. So it's okay if it's a Facebook account or a Gmail address of an individual. Okay, then it's acceptable, I think. But if you want to build a sustainable business, then you don't want your supplier to change the rules along the road. So, can they change the agreement without even telling you? Is there a notification procedure? And is there a possibility for you to opt out if they do? Check it, because it's valid, at least on the Belgian line, under most laws. If you agree that one party can make changes to the agreement, well, it's valid as long as they don't abuse that right. Best efforts or result, you will see that also the Amazon agreement, they do commercially reasonable efforts. So the difference between best efforts and result is that if it's a result, then the supplier has to provide that result. If he doesn't, then he has to prove that it wasn't his fault. With best efforts is the opposite. There, the provider will do its best efforts, and it's up to you to prove that he committed a fault. But most of these vendors try to go even lower. Instead of to generally accept best efforts, what you are supposed to do as a professional, it's commercially reasonable efforts. What that is, I don't know. It's some kind of best effort, but if it's not commercially interesting anymore for them, they don't have to do their efforts, I guess. So if it's really an important thing for you, negotiate it, try to have a result base or a firm commitment.
One question. Amazon went down somewhere last year for a few hours in one zone.
Mm-hmm.
Did they use this to say it wasn't reasonable to expect the service to survive this?
I have no idea. I don't know what they said, but I think they will just have paid 1 month of service credits, because that's the standard what they give. If they don't meet their targets, you get 1 month of credits. They don't refund it, but you are entitled to a free month. So I guess they will have done something like that, but I'm not sure. I didn't follow that case. Applicable law and venue, limitations on legal claims. So it's one thing to have to know and to be able to prove that your provider breached the contract. The other thing is to be able to get a remedy. And then, for instance, with Amazon, well, there you need to go to the state of Washington. It's not really feasible for the average Belgian small company, and probably other European companies, to go to the state of Washington to litigate with Amazon. So if it's an important vendor for you, not necessarily Amazon, but if it's an important service to you, make sure it's closer to home. Also the laws that will apply, there are differences. So take a look at it. If it's really important to you, make sure that you actually can enforce your rights, because otherwise you couldn't as well have a contract at all. And for instance, look at the details. For instance, with Amazon, you need, within 10 days you have to file your complaint after billing cycle. So be on time, don't forget it, and follow their procedures. For Amazon, for instance, you have to prove that they didn't meet their targets with your own log files. So if it's really important for you, I don't know if somebody of you uses Amazon and keeps tracks of his own log files to be able to prove if something is wrong. If they didn't meet their targets, we would suppose that Amazon would keep a track of the targets themselves, but actually contractually they put a burden on you, and a lot of suppliers do it. So it's an important service. Look at your contract and see who needs to keep track of the service. So most vendors offer a service level agreement. You will find it, and often it's in big letters, 99%, 99.9%. But that's not enough. Is it meaningful? You have to ask you that question. So one thing is the service level, but can you verify, we just said it, can you verify the service level? How is it calculated? I had a case with a client where the CEO of my client said, okay, my mail doesn't work because I need to wait 6 minutes just to open one mail. So he said it doesn't work. And then the provider said, no, the lights are on, you just need to be patient, but it works. So what does it mean, 99% availability? For my client it was not available because it didn't meet his needs. For the provider it was perfectly online. So what is your 99% and how is it calculated? Do you need to have your own log files, such as with Amazon? If it's the supplier who has the only one who registers, can you audit it when it's important to you? Yes or no? Because otherwise you just need to trust these figures. Then what compensation will you get if you were able to prove that he didn't meet his targets? Sometimes it's just mentioned, well, then you're allowed to terminate the SLA agreement, but then you don't have any support or any service at all. So that's not really an option. For Amazon, for instance, you get service credits against further use, no refund. So if they don't meet their targets, you get 1 month of free service. Is that enough? Does it really compensate your loss? If it's not a critical service, it's no problem. If it's a critical service for you, think about it and see whether you can live with it. And also check the customer obligations. That's most often in the acceptable use policy. So the acceptable use policy sets forth the use you are supposed to make of the software. If you don't apply or follow these rules, then most often the SLA will not apply. So read all the documents if it's important to you. Then the liability, it's always in small print and big caps. Here it says that Amazon is basically not liable for anything, and most cloud providers do this. So the default legal rule under Belgian law and most legal system is that if you commit a fault, mistake, you have to remedy the damages you cause. But you can change that rule contractually. Most providers do it, so even if they commit a fault, they often are not liable to compensate you at all. And so if it's for a critical application, a critical service, you might want to be compensated if it just quits for any reason. So look at it. Customer data, so it's your data. Will your supplier actually keep your data confidential? A lot of suppliers don't promise to keep your data confidential. They can share them with whomever. Are there undertakings or disclaimers regarding security? With Amazon, for instance, they say that you, as a user, are responsible for properly configuring and using the service. So you have to make sure that there's appropriate security, protection and backup of your content. So not only you have to make your own backup, you also need to make sure it's encrypted in the cloud. Whether it's possible or not for your application, well, Amazon doesn't really care. They will try to keep it secure, but if there's a problem, because of this contract, it's your problem, not theirs. So if it's a critical, important service for you, and if it's important that your data are secure, and I guess that's often the case, well, then make sure that your provider has the obligation to make sure that your data are secure. And also for the backups, take care, because a lot of people, a lot of clients, I hear, okay, it's with Amazon, it's safe, they don't keep backups, but should something go wrong, or should something be against an Amazon policy and they delete your data, well, where will you get your backup? It's up to you to keep the backup with Amazon and with a lot of cloud vendors, unless you negotiate. Ownership of metadata, it's often a question when you want to exit the provider. There's no discussion about your data. If you upload pictures and files, they agree, okay, it's yours. But for instance, with a mailing program, when was the mail sent? It's relevant metadata. Is it in a chain of communication? Was there an invoice with it? And all these things, all the attachments, all these metadata, of whom are they? As a client, you would suppose they are yours because you introduced it. Some vendors will say, no, it's data added by our system, so it's my data, and so it will be difficult to leave that supply because you might lose your metadata. So it's best, if it's critical, if these data are critical for you, it's best to make sure it's in the contract that it's your data and you're entitled to be able to take them with you when you migrate. Under what conditions can customer data be deleted? Notification procedure. Well, some of these providers, they think that they may delete your data even without telling you. And sometimes it's for good reasons, sometimes it's for reasons we cannot understand. So that's, for instance, the Zwarte Madame policy we talked about. It's just against their policy, so they'll delete. And then if they don't even notify you, what will you do? So most providers will keep the possibility to delete data, but if it's critical for you, at least ask them to notify you before they delete. Data protection. On what grounds can the provider share data with third parties? Some providers say, okay, we will only share your data if we are compelled to by law, and that's logical. Other ones will just say, no, we will share your data if it's in our best interest to share, in our commercial interest, and then they will marketing your data as they like. So if it's important to you that your data are kept private, make sure that your provider doesn't reserve the right to share your data. Some of them really do. and that you will find in the privacy policy. Within privacy policy is for personal data. Well, these kind of things, even if it's not private data, you will most often find in the privacy policy. In the cloud contracts, there is now a debate going on whether who is under European directives. We made a distinction between the processor of the data and the controller of the data. For instance, if you're a company and you've got customers, and then the company is the controller of the data of the customers. They give these individuals give their name and address to buy stuff with you. So you control these data. You don't have to process these data yourself. You can allow a third party to process these data. So you can, if you're a cloud provider, your administration system or accounting system is in the cloud, then in principle the cloud provider will just process the data. But sometimes the cloud provider does so much service that you don't know anymore who controls the data, who decides the processing of the data. Is it still the owner, the company of, or is the cloud provider becoming the data processor? It makes a big difference legally, because on the processor or all these, or the controller needs to comply with the data protection directive. The processor has way less obligations under these data protection directive. So if you as a supplier have a cloud service and you start doing more with the data, take care, you might become a data controller yourself under the directive without actually knowing it, and then you have to comply with way more obligations. And using individuals to evade privacy issues, it's something that...
Oops.
Well,
No, it's
Power.
blackout.
No UPS?
well, my computer, yeah, it's probably the battery of the computer. So,
No SLA.
well, I guess I can just continue with an explanation about how, for instance, Facebook, but a lot of cloud vendors use individuals to evade privacy issues. How do they do it? Well, the privacy laws, they don't apply on individuals for their personal use. So instead of sending mass emails and sharing information themselves, they just allow and entice the user to send these emails to the entire to their entire address email book. So it's their reasoning is, okay, it is not us who violate, or we don't violate any privacy laws, because it's not us who send these emails, it's the users who opt to it, and they are entitled under this exemption because they do it for their own private use.
They had to stop one of those services, right? They had to stop one of those features where you can spam a lot of people, even though it's an action that you do as an individual.
Well, yes, there's more and more people. It's like a void, and once your data are on, let's say, Facebook, and Facebook says, well, it's not our problem because it's people sharing. Well, if it's just sharing with I don't know, I think I've got 70 friends that I consider still private use, but Lady Gaga has 32 million friends. Well, their voice is coming up to say, okay, individuals, they must be responsible and they will become liable to. It's no private use anymore once you've got 5,000 friends. And the same, there are voices going up to say, okay, if you entice your customers to do it like this, you're responsible too. So, but at the moment, it's some kind of a void and a grey area. Do you think this is going to work then?
Warming up, I presume.
Well, my 10th point is service continuity. Under what conditions can the service be stopped or suspended? Most of these services, they reserve the right to just stop the service for any reason. and then what happens if they decide to? It's because sometimes it's because you infringe a policy, and you can still understand that because you can read it, but sometimes it's just because it's not in their best commercial interest or to stop the service because one of their business partners changes policy. So it might be elements out of your hands, and it's just stop the service. So it's for you a critical service. Have a look at it. Amazon, for instance, reserves the right to stop the service or suspend the service for so many reasons that are out of your hands, that it's not a reliable service.
You've chosen Amazon as an example. Do you know whether similar contracts exist for European cloud providers? Could a European cloud provider produce
Similar agreements? Yes, sure.
acceptable use policies that look like that?
Yeah. It's coincidence that I took Amazon, but most of them are the same or similar. Yes, the standard default contracts are like this. It's typical. It was the same with the first software outsourcing agreements. There too, the vendors thought, okay, we need to be able to scale business, and we need to be able to be sure, and the clients must take our service as is. Well, it changed, and because there is competition, and customers start noticing that they are able to negotiate these contracts, and so that change, it gets more mature. And in my expectation, these cloud contracts will become more reasonable too in time. It's just because it's newer, and they just bring this service now as it is. But we see that these contracts are open for negotiation, and once you have, as a vendor, when you every time needs to negotiate a certain point, and every time you have to agree to change it, in the end you will change your default rules, because it's a burden to always negotiate it. Then how fast can be migrated to another provider? So when you actually start a cloud service, you already should start thinking about your exit, because otherwise you might have a vendor lock-in and take care. How fast can you migrate? What kind of assistance will they have? Can they just terminate your agreement and your service because you didn't prolong it? One of my clients, they were moving, but they had a delay of like 1 week. Well, they had to buy a new 1-year contract. So it's important, if they had negotiated and had foreseen this when they entered into the deal, it would have saved them thousands of euro. Now they just had to purchase an entire year, and sadly without any reductions, because they weren't a good client anymore. So you're completely depending upon them if you want to exit. So it's them. There is no obligation, at least under Belgian law, for a supplier to assist, to help their clients to leave them. So if the contract is terminated, it's just it depends upon their goodwill. So it's best to, when you close the contract, to already think about what you need of them. Then my last point, the prices. The worst thing that you can see, and sometimes it happens, is that the supplier can change the prices if he likes to, and often, sometimes it's within some caps, for instance with a maximum of 5%, or with a maximum of a certain index. But sometimes you just say, okay, we can change prices if we need to, if we think it's necessary. Well, what will you do if your supplier just changed prices? But how are they calculated? You see a lot of ways to calculate prices. Sometimes it's per data volume, sometimes it's the number of times somebody clicks a certain icon. So it's for a customer, it's difficult to follow track of this. It's the supplier who will have to keep track of this. Well, how are you going to control it? Maybe if it's important for you and it can become expensive, you can maybe do an audit. There's no, I don't really have a problem in the way they calculate prices. It's completely fine. It's just important to see, okay, how can I keep track of it, and am I sure of my prices over a certain period of time? Can they double my price next year? So if it's a critical service, take care of that, look at it. So in global, is it recommended to serve, to use the cloud from a legal perspective? Well, of course, it's recommended. Of course, it's a good service, and it has a lot of advantages. So yes, you should use it. But if it's a critical service for you, then negotiate the terms, because the terms, they will give you standard default. They will give you a lot of issues. So, not sure whether there are questions. Yeah, I just wrote a book. It's Belgian law. I don't know how many Belgian people are in here, but if the Belgian guys want to know more, you can order this book. There's way more that what I spoke of in that book. But the other ones, just ask questions now.
Actually, I have two questions. And the first one was, now we have clear that we should negotiate the terms before, but in some situation I believe that it might be a bit difficult to really enforce our rights when the time comes. For you gave the nice example of somebody deleting your file, right? How am I gonna prove that? I have one file somewhere. What piece of document can I give to a judge to say, you see, this file was there, it's not there anymore?
It's a factual question. Often all your files will be gone, and then it will be more easy to prove. But okay, the problem is, but it's a factual problem indeed. If you have your own backup or your own system, but it's one of the issues. Think about it when it's really critical, and these data are critical to you. Think about it when you enter in this agreement, and when you enter this service. What if it goes wrong? How will I prove it? It's up to you, and no lawyer can help you. It's a factual thing. If you can prove it by facts, and then you will have a chance. If you can't prove it, then too bad.
And the other question was, in certain situations you can also even complicate things more, because you might have two different cloud providers. For example, you might use Heroku, which is a platform as a service provider that bases its service on Amazon EC2. So in that case, you have to accept two different agreements. The first one is, actually in practice you accept only the one with Heroku, but then what happens if there is, for example, a conflict in those two?
In principle, you have to look who is your contractor. If you only have a contract with Heroku, then it's their problem if their supplier Amazon can't deliver. So then you only have to address Heroku, and they must make sure that they are backed up by Amazon. If they don't do it, well, then it's at their risk. Of course, sadly, you might become the victim of it, but legally, technically, it's their problem, unless they specify in their agreement that you accept the Amazon services and that they are delivered as is. So you have to look into your contract, but in principle, as a customer, you only have to look at the prime contract.
With personally identifiable information or medical information, I believe that currently it is not possible to use a company that has an office in the US, because they have to conform to the US law. Do you know anything more about that? How that works?
Well, it's these safe harbor rules. So if a company has a branch in a European country and process data here, then they are subject to the European Data Directive, and they must adhere to it. Problem is that American branches or Russian branches or Chinese branches or whatever, they do not apply these strict rules. Sometimes they promise it to do it, and then it would work under the safe harbor principles, but sometimes they don't. I think you are referring to the Patriot Act. because there the Patriot Act says that the US government can access all the data if they want to, but that is not really a problem under the data directive, because also the Belgian government, if they think that, I don't know, Mr. X has child porn or something in the cloud, they will just go and grab it. So the fact that a government has rules under which they can access the data and a company needs to adhere to them, that's no problem. The only problem is that in the United States you don't have a law on, well, if it's on minors, I think they do, but the average consumer's data isn't protected. They have the policy that the industry must have their own policies and then adhere to the policy. So if a US company says, I will apply the European rules, then and they promise it, they will have to do so. But if they say, okay, we don't respect your privacy, we will share them, well, then they don't have to respect your privacy. So that's a problem, not directly the Patriot Act. Any more questions? Yes?
You said that almost all, if not all, of those contracts are very unilateral.
Mm-hmm.
Are you aware of examples that do the good thing and have more balanced contracts? Or?
Well, if you negotiate them,
But
then they standard? No, not really. Not really. There have been a lot of researches on this, but always the result is no, they are unbalanced. But I think that a provider could make it as a selling point, because all the clients, they will go to people like us, the legal service, and then we will raise the issues and red flags. So a provider that gives default good conditions and says, okay, I give a good service, so I warrant that I give a good service, and if I don't meet my SLA, I won't give you a 1 month future service credits, I will actually refund you. Well, I think at least it will pass more quickly through the legal services and the business people on the floor. They will get an okay from the legal service instead of a red flag.
So maybe we should.
How do you think it is possible to negotiate between Google and the person if the corporation is able to hear human voices?
Yeah, well, if it's just one person for a Google account, of course they won't. But a colleague of mine did it for 5,000 accounts. So that's a value of 5,000 times $40. So for Google, that's really peanuts. It's nothing, and still they did it. So I think once you start paying, and it's once you are important enough for them to care, and especially in these economic conditions, nobody wants to lose clients, and they have to meet their targets and grow. So they don't expect them not to negotiate, but just ask. They can always say no, but you should ask.
But why? Does it make sense to ask if they always answer no, and if they intended to raise their profits to gain money, and they may make exception for big customers, but they never make exception for personal customers. So maybe for a person it is better to ignore such a huge providers. They cannot negotiate.
That's of course true. If you're too small, then I guess you can't
So
negotiate
we are
with
all
Google. But,
small, and we all possess Google Mail accounts,
mhm.
and we are all occasionally, sometime sign this agreement,
Mhm.
and this agreement may contain any conditions that we cannot even imagine.
Of course. So I'm using Gmail too, but it's only for private stuff, and I realize that it can be over anytime. So if you use it for critical purposes, at least make your own backup, download it, and I think you still can accept these services. I do it myself too, but at least you need to be aware that there might be a problem.
Yes, we need to be aware. Exactly.
Yeah, and then there was a guy, it was a couple of
And-
weeks ago.
And the result of this awareness is always the conclusion: avoid the huge cloud services.
Well, that's your conclusion, and it's you're right. I don't avoid them because I think it's a great service what Google's offer, and I just like Gmail and calendar and all this stuff. I just am cautious with it because and I will never use it for my law practice because it's to me it doesn't offer enough safety. So, but for my personal purposes, I just love it. But if tomorrow they quit, okay, then I will find another supplier, but it won't I won't be harmed. And that's a message from me to you. You can all work with these services, at least in my opinion, but know what can happen if you tomorrow there was a guy a couple of weeks ago, an English guy who twittered, "I'm going to New York and I will burn the place" or something. And they arrested him and in JFK, and know that these kinds of services are followed, and if you write these kinds of things on your Gmail account, things can happen. So don't rely on them too much. It's a question of policy, of technical issues. If it's cloud services you want to use for critical services. Yeah, make sure you are backed up really well. Know that these things can happen, or negotiate these contracts. Okay? Thank you for your attention.